Can Donald's DC conspiracy trial go to trial before the November election? That is the question. Welcome to Law and Society. Please subscribe and let's get started. I've been counting days, and a lot of us have. I want to do a brief rehash of where we are and where we started. So, last year in August, Jack Smith indicted Donald Trump on four felony counts. One was um, conspiracy to defraud the United States, the other one was conspiracy to obstruct, then it was obstruction and attempted obstruction, and the last one was deprivation of rights under color of law. So, those charges were in the indictment, and as Judge Chutkan, who was assigned in the case, started going through pretrial procedures, Donald Trump kept bringing up motion after motion after motion, including gag order motion, just to flood Judge Chutkan with motions to rule on. And Donald's attorneys audaciously even said that they would do that when Judge Chutkan set the trial date for March 5th. Well, February rolls around and Donald Trump appeals. Donald Trump's appeal is he resoundingly loses it in the DC Circuit. DC Circuit and Judge Chutkan both held that former presidents don't have immunity against criminal prosecution, and Donald Trump appealed. On appeal to the Supreme Court narrowed the question to whether, and if so, to what extent does a former president enjoy presidential immunity for conduct alleged to be official acts while in office. Well, that argument, there were oral arguments on it, the briefs were exchanged, and the oral argument was April 25th. And from April 25th to today, there has been no movement. The Supreme Court has essentially withheld their judgment on this extremely important case. Mind you, I understand and acknowledge that this is the last case on the docket, but this is also an unprecedented case. This is also a case that is holding up a criminal trial of unique importance. In holding this up, the Supreme Court is denying the public its right to a speedy trial, which is our legal right, and also denying our political right to know the truth about a certain candidate before the elections happen. So, all of this going on, and the Supreme Court has not said a word about it. And I wouldn't be surprised if the Supreme Court, opines on it on the very last day of their opinions, which could be this coming Friday or the Monday after that. So I think the 28th of June or the 1st of July. I was counting the days of that, and on counting the days, it came to about September 20th would be the day that Judge Tanya Chutkan would be able to first start the trial, because Judge Chutkan has previously said that it would take about 80, 81 days for the pretrial procedures to complete. I'm sure that Donald will try his best to derail those pretrial procedures continuing as well. And assuming that the case is ready to be tried in September 20th, Judge Chutkan would have to make that call. That is 6 weeks before the election. Can the case happen 6 weeks before the election, or will Judge Tanya Chutkan wait until after the election? I believe that because of Supreme Court's intervention and delay, and this gift of delay that they have given Donald Trump, Every single day that the Supreme Court delays is a day that is taken away from Judge Tani Chutkan in her assessment of whether to hold the trial before the election or not. And if the Supreme Court goes to the last day and waits until the last day of uh, issuing opinions in this end of this term, then we will have essentially foreclosed the opportunity to see this case go to trial before the election. That it's going to be Judge Chutkan's call, and it's going to be what Judge Chutkan thinks whether the case can be finished in 6 weeks or not, and whether she will give consideration to the fact that Donald Trump is the Republican nominee and running for president. I mean, it is an extremely unique situation, and I think that Judge Chutkan uh, will restrain herself, and I think that she will wait until after the election. And I'm telling you all this to say that our Supreme Court has betrayed the people just by sitting on the case for the last 8 weeks and having stayed the case for the last 4 months. The Supreme Court gave Donald Trump the gift of delay, and the Supreme Court effectively interfered in us knowing the truth, interfered in us having a speedy trial. Mind you, it's not going to go on any book or any record of how long the Supreme Court took to come to the right decision. So, as Professor Lawrence Tribe brilliantly put it, it they are doing it just for Donald Trump. It's not going to be the case with other presidents. It's one of those, one of those gray areas where the Supreme Court can do whatever the hell it wants as it holds the case. And here it has decided that it's in its best interest and in the country's best interest to withhold ruling in this case so as to delay the underlying criminal case. I believe that it's shameful. I don't know how much of that blame would go to all the other justices, but I'm sure Justice Alito and Justice Thomas are elated about this. And I would say shame on Chief Justice Roberts for delaying this case for this long and not having any sort of guardrails for the Supreme Court, no ethical boundaries, no checks. The Supreme Court now runs as a rogue institution that effectively denies the people our right to a speedy trial, effectively denies our right to know the truth about a candidate before the election. It is unprecedented because Supreme Court has ruled quite quickly in like 4 days in Bush v. Gore, and in many other cases where the issue was not nearly as important as answering whether the person who is running for president, one of the candidates, is a convicted felon or not, if they committed crimes sitting in the very office which they are now seeking, and whether those crimes amount to the level of him not deserving that office again. The American people had the right to know the truth about that. And the Supreme Court has foreclosed that. And it is a travesty of justice. It is justice denied because there is a contingency, there is a chance that Donald Trump may win. The chance isn't that high, but it is there. And because there's a chance that Donald Trump may win, the Supreme Court has put our country in a whirlwind. And should Donald Trump win, has the Supreme Court thought about what would happen if a dictator came into power? They would have no incentive to have a Supreme Court, or they would appoint two more justices or more justices if uh, uh, and then keep the legacy of the court, as Professor Tribe said, as conservative as possible for years to come. So the Supreme Court did you, me, the American people a great big disservice by delaying this case, by simply withholding ruling on this case. And we will know what the substance of the ruling is. We will then learn how long Judge Tani Chutkan will take for the pretrial procedures. Maybe she will shorten that 81-day time. Maybe she will expedite the process. Trial court has broad discretion in how they manage pretrial processes. And this case has been on hold for over 4 months now. So it's up to Judge Tani Chutkan to a large extent once the case is remanded back to her, because it would be ridiculous, as Professor Tribe said, to think that the Supreme Court would say that former presidents have absolute immunity from criminal prosecution. It's an absurd thing for the Supreme Court to say. I don't also believe that the Supreme Court would say that. I think at the end of the day, the Supreme Court will say that, you know, there is no immunity for private acts, and former presidents don't have criminal immunity like incumbents do, and especially for private acts, nowhere in the ambit of their official duties, those acts are amenable to the laws. So, with that said, I'll close today, and let's wait till next week. So, thank you very much for being here, and please like and subscribe if you are new to my channel. And I'll talk to you soon.